Thank you all for being here today, and I apologize for the delay, but it's that time of the year. Members are running bills and other committees and doing hard work for their constituents. Madam Clerk, if you'd go ahead and take the roll, please. Members. Very good. I believe everyone's punched in. Madam Clerk, if you go ahead and take the roll, please.
Mr. Chair, you have 18 members present. You have a quorum.
All right. Members, anyone have any personal orders before we get started? Any personal orders or announcements? Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. Members of the committee, I hope that you all had an opportunity to enjoy one of those delicious slaw burgers that were upstairs. That's Speaker Marsh and I, we share Lincoln County together, and that is Lincoln County's Hamburger Day on the Hill. And so they're up there, and we've got a lot of folks from our district that are here today. So thank you all for doing that for us.
Members, any other personal orders before we get started? I have Ms. Davis, Ms. Representative Davis, Vice Chair Davis.
Thank you, Mr. Chairman, and thank you, committee. I just want to welcome our Knox County Clerk, Mike Hammond, who's here today. I had the privilege and honor of serving with him on Knox County Commission. He's a wonderful man and a great individual for our community. So I want to say thank you, Mike, for being here today.
All right, members, anyone else? Any personal orders or announcements? Representative Hardaway, you're recognized.
Thank you, Chairman. Even though she's on our agenda, would it be proper to recognize one of our favorite judges? If we call Valerie's name, would she? Well, never mind. We won't do that.
Yeah, she's going to have an opportunity to grace the committee with her presence, and so will Judge Sword in just a moment. Members, any other personal orders or announcements before we get started? All right. Without objection, we're going to move forward. Members, we do have a calendar, but before that, we have two very special judge confirmation. We're going to have confirmation hearings. So without objection, members, do I have any objection going out of session and taking up our confirmation hearings for the Court of Appeals position in West Tennessee, and then the vacant Court of Appeals position in West Tennessee, and the vacant Court of Criminal Appeals position in the Eastern District? Any objections? Seeing none. Okay. Ms. Merrick and Mr. Mitchell, either one, I guess. Ms. Merrick, would you like to approach you could have a seat or wherever you'd like to sit to make your opening remarks for both of our judges today? Yeah, you want to sit down? Go ahead. And ma'am, if you would, I know most of all of us know you. If you would just introduce yourself and what office you're with, and then I'll just open it up for you to make remarks for our judges.
Thank you, Mr. Chairman.
Thank you,
committee members. My name is Erin Merrick. I'm the Chief Counsel for Governor Lee. Today, I continue our 7-year partnership of appointing and confirming experienced and conservative and strong Tennesseans to our appellate bench. I have the pleasure today of introducing two of Tennessee's finest, Judge Valerie Smith, who's the governor's nominee for the Court of Appeals in the Western section, and Judge Steve Sword, who's the governor's appointee for the Court of Criminal Appeals in the Eastern section. I'd like to take a chance to give some brief bio information on both of these judges, and then we'll make them available for questioning, first Judge Smith and next Judge Sword. So without further ado, Judge Valerie Smith has served on the Circuit Court in Memphis since 2016. She was originally appointed by Governor Haslam and has retained her seat through multiple elections. Prior to the bench, she was a prosecutor in Memphis. She was an ADA for 5 years, and then she litigated in private practice for 10 years. She has tried over 50 jury trials and numerous bench trials in both the civil and criminal courts in the state. Currently, her courtroom hears exclusively civil matters. She has disposed of over 4,000 cases and presided over 47 jury trials and hundreds of bench trials and dispositive motions. Outside the courtroom, Judge Smith is involved with civic and faith-based organizations, among them the Section 901 Youth Athletic Fund, Memphis Gridiron Ministries, the Shelby County Republican Women, and the Shelby Republican Women of Purpose. She's a lifelong Tennessean. In 1993, she began at the University of Memphis, where she earned a bachelor's degree in business and a law degree, and she became a permanent Memphian in 1998. Now, if I could briefly move on to Judge Steve Sword. Judge Sword has served on the criminal court in Knox County since 2011, and he served as the senior criminal court judge since 2020. He began his career in a small private firm, but soon became an assistant district attorney in Knoxville, where he remained for 16 years. His primary assignments in the Knoxville DA's office were as a juvenile court prosecutor, criminal court prosecutor, and a prosecutor in the child abuse unit. His courtroom today hears exclusively criminal matters. At any given time, Judge Sword oversees approximately 600 pending matters on his docket. He's presided over more than 350 jury trials, including more than 40 trials for first-degree murder. Outside of the courtroom, Judge Sword has served as a trustee of King University in Bristol. He's a board member of the Knoxville Leadership Foundation and an elder at his church. He served for 10 years in the Army Reserves, both domestically and abroad, and he is a decorated JAG officer. He's lived in Tennessee for over 30 years. He attended King College, where he earned a bachelor's in history, and then graduated from UT Law School in Knoxville. As I mentioned, I'll make them both available for questioning in a moment. But first, I'd like to remind the committee, we've gone through this a few times before. I'd like to remind you of the limitations imposed by the Code of Judicial Conduct. There are certain questions that the judge candidates may not be able to answer. They are not trying to evade your questions, but the Code of Judicial Conduct requires impartiality, and answering certain questions about personal viewpoints or critiquing pieces of legislation or other pieces of law, et cetera, is outside the scope of what they're able to do today. It's important that they remain available to hear cases on these matters that may come before them and not be put in a position to recuse themselves. So I thank you all for understanding. And with that, Chairman, if you agree, I'd like to bring forward Judge Valerie Smith for questioning.
Thank you, Ms. Merrick, for that. And that sounds great. What we may do, since we have two, we may bring both judges up and allow them to sit and
Very good, Chairman.
entertain questions from the committee. So members, any objection to doing that? No. Okay, very good. Judge Smith, Judge Sword, if you all come up and just have a seat there at the table, we'll turn both of your microphones on, and we'll open the committee for questions. Members, just be sure when you ask a question to direct it to either Judge Sword or Judge Smith to answer that question. So first on the list, I have Representative Bolso.
Thank you, Mr. Chairman, and welcome, Judge Smith, Judge Sword. My question is for Judge Smith. I read your very impressive application, Judge Smith, and one of the things I noted was that in response to question number 40, you indicated that in your view, courts should interpret laws in a neutral and objective way. And that very much reminded me of Justice Antonin Scalia's judicial philosophy in his book, Reading Law, where he noted that really judges should give a fair reading, not a strict or a liberal one, but just a fair reading. And I'd be interested in having you comment on your philosophy that judges should give statutes a neutral and objective interpretation and how that aligns with Justice Scalia's view.
Judge Smith, you're recognized.
Thank you for the question. I appreciate certainly your question and understand that is an important thing for the judiciary to do. It is my belief that it is the role of the judiciary to interpret the words as passed by this body and apply them to the facts in a neutral way. In the answer to the question that you're speaking to in my application, I believe I used the analogy that the law cannot be stretched or tailored to fit a given amount of circumstances. No matter what sympathies a judge might have, the law does not leave room for that, but it must be interpreted as written.
Representative Bolso, any follow-up, sir?
Thank you, Mr. Chairman. No, thank you, Judge Smith.
Thank you.
Very good. Next, let's have Representative Travis. You recognize, sir.
Thank you, Mr. Chairman. It's really not a question. It's just that I got to spend some time with Judge Smith and Judge Sword this morning in the office, and I think they will be a great asset to the great state of Tennessee. And welcome to you, and thanks for being here, guys. I appreciate y'all.
Thank you, sir.
Thank you.
All right, very good. Next on the list, I have Leader Lambert has stepped out of the room, is in the room. Let's give him a moment. Always working hard, our fearless leader. I wouldn't dare.
Well, Mr. Chairman, I will say the Budget Subcommittee Chairman is in the back of the room, and this time of year, we are all very kind to Chairman Williams. If you are not, you'd better be, okay? So here's my question really for both of you, and one of you can take the first question first, and then the second one, we'll swap it up, okay? That way, nobody gets an opportunity to be too well prepared. So here's my pop quiz questions, and I hope you'll like them. So which U.S. Supreme Court justice, dead or alive, generally shares your judicial philosophy? Whoever wants to go first.
Okay, I'll start with that
Judge
one
Sword,
because it's easy.
you're recognized.
So if we were in my office right now, I'd show you two autographed pictures. One is me with Antonin Scalia, and the other is Clarence Thomas. The judicial philosophy that I've learned from them is one of judicial restraint. I think they've been champions of showing what the role of the judiciary is and not to overstep that. If you asked me to pick a favorite, I would probably have to say Clarence Thomas, because when he visited, what he wanted to talk about was UT football, and he won me over on that.
There we go.
Leader or Judge?
Well, I could pick many favorites. However, the one that comes to mind when I think about styles that I admire is Justice Kavanaugh. Justice Kavanaugh employs a very plain and easy reading style. Whenever you read his opinions, it's something that average, ordinary people can understand who may not be lawyers. And it is something that I try to do in my own writing. Further, in his own questioning and oral arguments, he asks very clear questions that are easy for people to understand. And on another note, from things I've read about him, his law clerks all adore and go back for reunions over the years. And that's something that I will try to emulate.
Awesome. Leader?
Mr. Chairman, and thank you both for that. I appreciate it. The other question I would ask, and you've alluded to this in saying who kind of the justices that you admire are, but what's the role generally of the judiciary in your opinion, and specifically the appellate court, since that is where both of you may be headed? Judge, you want to take that one first?
Well, the appellate courts serve as error correction. We're in a position to review how the law has been applied to the facts in the trial courts. Of course, changing precedent, those types of things are things that are done at the Supreme Court level. So for our position, I don't mean to speak for Judge Sword, certainly, but we're one of an error correction court.
Leader? Oh, excuse me.
What I'd add to that is the role of the judiciary really is important to follow the Constitution. We have separation of powers for a reason and those checks and balances. And so the role of an appellate judge is to make sure that the lower courts follow those constitutions, follow the law, and make sure that they haven't overstepped their bounds.
Very good. Leader Lambert?
Chairman, the only follow-up I will say is I wish you both the best. I'm sure everyone here will have a lot more questions. But if you ascend to these appellate positions, we really do mean the stuff we put on a page. And so when we send a law to you, please interpret it as it's written, based on the facts before you. And then if we have erred in some way, indicate that to us. And I think I share that with both of you all in my office. Obviously, you can't do so while a case is pending, but after you've issued your ruling, I've had many judges over the years, and I know Chairman Farmer has had the same, and others on this committee probably have, where I'll get just a very nice email from a judge saying, hey, we just issued an opinion. You might want to check it out. And so it's good guidance for us on ways that we can continue to amend the law so that we don't put you in positions as judges where you may get to a result that you wish you didn't have to go to based on the reading of the actual laws. So thank you very much, and good luck to you both. Thank you.
Thank you.
Very good. Next, Representative Powell. You're recognized, sir.
Thank you. I'd like to follow up. I appreciate you both being here. To both of you, if you could, regarding the balance of powers. I think in this country, we have seen an executive power that has exceeded constitutional authority, and we're seeing threats on the judiciary as we speak. Judges being threatened to be removed. Can you speak to how you would obtain, or you would maintain judiciary power and also your ability to make decisions without fear of the executive interacting?
Sure, I'll start. The obligation of a judge when they take an oath of office is to support the Constitution, and that is what your number one priority is. And there are provisions in the Constitution for removal of government agents, including judges. As long as those are being properly followed, then that's okay. But we need to make sure that the Constitution is being followed, and that's really the role of the judge, not to pick winners or losers, but to make sure that whatever side is fighting a battle, that they're fighting fairly.
I would echo Judge Sword's comments. When we take our oaths, we take them very seriously, and what we are bound to do is not something that will be affected by fear of another branch of government.
Mr. Powell, any follow-up?
Yes, just another question I have for you, and I've asked this for other judicial candidates to come before this committee. As somebody that is in the minority party, I know you follow the strict interpretation of the law, you said, that's written. However, we do have a process where you're in front of a legislative process that often there's committees, there's testimony, members speak of intent. Oftentimes it's very important for us in the minority to make sure that those questions are asked so we can get that on the record. Can you speak to how you would look at intent when laws are passed, specifically for those of us who are in the minority, that we still feel like, we're often asking very important questions, and we want to make sure that things are on the record. Your ability to go back, look at those, reflect on those, or do you just strictly look at the law as written?
Well, thank you for the question. I believe that the best reflection of intent is what comes before me in the law that is passed. There is debate within this process, and you all vote on what is going to be the law, and that is the best representation of intent for me to review when I'm applying or in the role that I'm seeking confirmation for, review of the existing courts. Or as a trial judge, I look at what we have now and apply that to the facts, but the best representation of the intent of this body is what is passed.
I'd follow up with what Judge Smith says with a great example. There was a case that came out of Tennessee Supreme Court recently, State of Tennessee versus Curry. And in Curry, an individual had been charged with unlawful possession of a firearm by being a convicted felon. And the law says that if that prior predicate felony was for a crime of violence, it enhances the punishment. And there's a definition for crime of violence in that chapter. It's 39, chapter 17. And it says a crime of violence includes, and then it lists a number of offenses, aggravated kidnapping, any form of murder, aggravated burglary, aggravated robbery. Notably, it does not include the word robbery. And so there was a case that was tried recently in another jurisdiction, and the predicate felony was for robbery. And the judge looked at it, the Court of Criminal Appeals looked at it, and then finally the Supreme Court looked at it, and they said, when the legislature used the word includes, what they're telling us is this is a non-exclusive list, that maybe robbery is, maybe it isn't. And when that opinion came out, this body acted very promptly, and your intent is, well, we intend for robbery to be part of that. So there's a bill before the legislature right now to include robbery to the definition. So I think it's a beautiful example of how the judiciary and the legislative branches work together to make sure that that intent is clear.
President Powell.
Thank you, Mr. Chairman. One final question. I appreciate both of those answers. And I will say sometimes we're not always allowed to debate in this committee, and I think that's one of the reasons it's important to always allow debate. I will say that some of my favorite justices throughout U.S. history were appointed by Republicans. And I think, unfortunately, one of the things we're seeing in this country is extreme partisanship, even invading the judicial branch. And recognizing the fact that you're both appointed by Republican governor, how will you handle, tell me your philosophy around partisanship and the judiciary when you're up on the bench? Thank you.
Well, being from Shelby County, I'm in a unique position to answer that question. We run nonpartisan in Shelby County. So partisan politics have never been really a consideration for me when I've been in my judicial role currently, and I can state that they will not be in the future.
The motto for the judiciary in Tennessee is a Latin phrase that I cannot pronounce, but in essence what it means is that let justice be done though the heavens may fall. Any case before me is a case that I want to seek to do justice, whatever the consequences are. Whether that is against my personal opinion of what the results should be or my party's preference of what that results would be, I'm going to do justice according to the law.
Very good.
Thank you.
I have next on the list, I have Representative Garrett.
Thank you, Mr. Chairman. Judges, thank you all for being here. I'm excited to both vote for y'all's confirmation today, but I do have a couple of questions for you that hopefully will. Most people that come before judges are nervous because they don't know what to expect, especially if you're in criminal court. That means you've done something wrong and you could lose your freedom. Right? In civil court, I mean, that's a last resort. There could be some sort of an agreement to be made, settle the dispute, and you're often the person that gets the worst of the worst cases that come before you and have to decide one way or the other based upon the facts before you. So my question kind of involves that for folks that may never have touched the judiciary system, that are scared to death to go to court because they don't know what they did wrong, and they just don't understand the process, right? Because a lot of even my clients, as a practicing lawyer, fear what it's going to be like when we go to court. So I asked this question in that regard is not divulging any specific case, but what has been probably the most difficult case that you've had before you, Judge Smith, as a civil judge, and then, of course, Judge Sword as a criminal judge? What's been the most difficult case that either kept you up at night? Maybe there's a lot of them, maybe there's none of them. And then what's the best case that you've had that you felt, this is why I'm a judge. This is why I do what I do. This is why I want to further my career, challenge myself to be on the Court of Appeals, and do better things as a judge. What are those two cases that has brought you to where you are now and the reason why you want us to approve you for a bigger, better job?
Okay, well, I'm going to start with the worst, if that's okay,
that's
because
fair.
I'd like to end on a positive note. The worst case that I have presided over that kept me up at night, and my husband Dave is here, he can tell you it kept me up at night, involves an appeal from an FED action. I had a lady appear in front of me who had unfortunately trusted the wrong family members to help her with her affairs, and her home had been subject to a tax sale. The new owner of her home sought to have her evicted from her family home, and that was appealed to me. And though it broke my heart, I had no choice. So it was a very difficult decision. The best case, let me pivot to something more positive. When I was very, very early on the bench, maybe even the first couple of months, I had a young man appear in front of me who was seeking encroachment on a minor settlement. And I was, why would you want this? What's going on here? And the young man would not come into the courtroom because he was afraid. So I took off my robe. I went outside and just kind of stood around for a minute. And he said, I don't want to go in there. Nothing good happens in a courtroom. So I said, are you scared? What's going on? And he said, judges are mean. And eventually I talked to him and I said, what if I told you I was the judge? So he came in with me, and I heard all of the terrible things that had happened in this young man's life and why there was a settlement that he was seeking encroachment from. Many years later, he invited me to his college graduation.
Well, for me, I'll also start with the worst case. A friend of mine, he was a former colleague when I was in the DA's office, he worked as an investigator. He was called out to a home on a call of concern that this family hadn't been seen. And when the police entered the home, they found a couple who had been stabbed to death, bodies dismembered, put in some Tupperware to dissolve an acid. The mom's head was found boiling in a pot, and it was their son who had killed them. And there was a lot of difficult legal issues, including a search warrant that had been issued by a judge in Louisiana that I had to suppress the evidence that was obtained in that, which was very condemning of the defendant in that case. It was a gruesome case. It took over a week to try. The jury came back and convicted him. My best case is the exact same case. That happened in the middle of our COVID shutdown. We'd received orders from the Tennessee Supreme Court that we couldn't have in-person hearings for a period of time. And as soon as they allowed us to start having trials again, I tried that case first because that family had been sitting out there for over a year waiting for this matter to get resolved. Great lawyers for the state, great lawyers for the defense, lots of legal issues. Fortunately, I was affirmed by the Court of Criminal Appeals, and the Supreme Court denied it. So I was proud to get that very difficult situation settled for that family.
Very good. Representative Garrett, any follow-up?
Thank you, Mr. Chairman. Just one more final question. Thank you for that. It's lots of times we want insight because people do sometimes are a little intimidated by the robe and the bench and that. So y'all are human just like we are and have difficult cases that you all appear in front of you for facts that just are awful. So on the legal side of this, obviously you'll be on the Court of Appeals. You'll be hearing cases that have tried. You'll be good, learned lawyers will be providing you briefs that'll have all kinds of background on certain cases. And, of course, precedent is of utmost importance to make sure we maintain that. Sometimes it's appropriate to overturn that precedent. So I was kind of wondering what you all think as it relates to what the importance of precedent is. And to those that maybe not lawyers, that's laws that have already been passed by or case law that's been discussed and reduced to opinions, et cetera. I was kind of getting your insight. And maybe, Judge Sword, you can begin on that. And
Sure.
Then Judge Smith on the importance of precedent.
Yeah, I like using examples, as you've seen. There's another great example of that going on right now with the Second Amendment. So I have, as a trial judge, I am bound by the precedent of the higher courts, and that's what I follow. But there are times that that precedent has been abandoned, and we're seeing that right now in the Second Amendment. Post Heller and Bruin, it's clear that the Second Amendment provides a personal right. What we don't know is what level of restrictions the government has on firearms. They clearly have a constitutional interest in regulating firearms. We don't know now what the test is and what the balance. And so the latest direction we've had since Rahimi is you look at the historical context at the time the Second Amendment was adopted to determine, is this the kind of offense that would prohibit somebody from possessing a firearm? And so I've had two cases recently. One was a person who was a convicted felon and couldn't possess a firearm because he had a prior forgery, nonviolent offense. Another because he had smoked marijuana in the past. And since I am not really bound by the precedent that had originally existed, where I'd clearly say, yes, these are violations of the law, but now the court has to determine, I'm applying the precedent set, the new precedent set by the Supreme Court. And so that's really the one time that you will depart from precedent, when it's been abandoned by a higher court.
Similar to that answer, but I don't have the specifics of that kind of example. But precedent is to be followed by the Intermediate Appellate Court. When precedent isn't to be followed, it's because it's become unworkable and something that simply can't be followed. But that is something that generally will be addressed by the Supreme Court, the United States Supreme Court, and it's important for the Court of Intermediate Appellate Courts to follow precedent unless it's simply become unworkable.
Representative Garrett, any follow-up, sir?
No, sir. Thank you, Mr. Chairman. I appreciate y'all's responses. Good luck.
Very good. Next, let's have Chairman Russell. Sir, you're recognized.
Thank you, Mr. Chairman. First, I want to wish both of y'all the very best. I look forward in supporting your confirmation. I appreciate y'all stopping by the office and appreciate you putting yourself in this position. I'm sure it took a lot of hard work over the years and dedication. My question is, what prior experiences as a trial judge prepared you for a appellate bench position?
You want to go?
Well, being a trial lawyer for most of my career, at first in the ADA's office, or in the DA's office, I'm sorry, and then as a practicing litigator around mainly in West Tennessee, I brought that experience with me to the trial bench. Having tried all of the cases that I have, both bench and jury, I know what happens in those cases. And looking at them from an appellate view, I have a unique perspective, and I'm able to review those from the former eyes, hopefully, of a trial judge. So it brings a great amount of perspective in knowing how to review those decisions.
Yeah, I would agree with Judge Smith. I would say we're very prolific in Knox County in trying cases. I've tried over 360. I think I ended around 367 last week. And one of the things, you can go through experiences and not really learn anything from them, but I hope and believe that I've gained wisdom from those experiences. And when people ask about the role of an appellate judge versus a trial judge, the best sort of analogy I have for you, if the litigants are your players and the judge is the referee, the appellate judge is the replay referee. And so I get to slow everything down. I get to look at it from all the different angles. I get to take all the time I need, consult with other judges and see if that we could reach a consensus on it. So when you're having those conversations with these other judges, that prior experience puts you in the mind of, okay, I know exactly what that trial judge was thinking when he did this. I know what he was feeling. I knew there were 12 jurors looking at him, and he had 30 seconds to make a decision, and I have 5 months to make a decision on. And so that experience puts me in the shoes of that trial judge and hopefully makes me understand when deference should be shown to their decisions.
Very good. Chairman Russell, any follow-up?
Yes, Mr. Chairman. The only request I have is just make us proud. Thank you.
Very good. Representative Scarborough, sir, have you next on the list.
Thank you, Mr. Chairman. And I'll be brief. Someone actually asked a question very similar to what I was going to ask, and so I won't follow up on that. I will say thank you all for taking the time to meet with us, that we're wanting to meet with you, and then also for taking on this critical burden, the role we're going to need from you. So, again, thank you all for being willing to serve.
Thanks.
Thank you.
Very good. Thank you, sir. Next on the list, I have Representative Towns. Sir, you recognize?
Thank you, Mr. Chairman. And judges, thank both of you all for being here as well. And as my colleague just previously stated, for offering yourselves to this state, to this country to serve, and, apply justice fairly and equally across the board. It's already been talked about just a little bit, but I'm definitely big on the Constitution. I think that's a sacred document that we have as a guide to go by to keep the fabric of the country together. Okay? Now, it's amazing how hundreds of years ago people seemingly had far more sense than we do today, fabricating documents like that still work. If we stay in alignment with them, it seems to, allow the country to track along at a pace where people still believe in the country and believe in our justice system. When we lose that, we got a problem. We got chaos. And so you all talked about it, and it was good to hear you say it before I brought it up, as much as we can as it relates to the Constitution. And personally, Judge Smith, I'm very proud of you and the fact that you're here. You from our neck of the woods down there and been in the community. You and your husband doing great work, and it's good to have you here. And as already been said, good luck. Look forward to working with you as well.
Thank you.
All right, very good. Next up, Representative Hardaway, sir, you recognize.
Thank you, Chairman, and good afternoon to you. Do I call you judges or justices?
Judge.
Okay, all right. And I know a lot about Judge Smith. It's good to see you here, and you're certainly deserving. When I think back on these hearings, I often think about the hearings in the past and in anticipation of this one. I think about my old classmate, Gwen Rooks, Judge Gwen Rooks, retired. And one of the stories that she would tell is when she had a young man in front of her, and she was about to bring that gavel down on him, and he was asking out loud for justice. He just wanted justice. And Judge Rooks replied to him, "Sir, with what's before the court now, you don't really want justice, you really want mercy." So tell me, and you can be abstract or you can be drawing your specific experiences. Tell me how you balance justice and temper it, not necessarily balance, but temper it with mercy.
Well, not presiding in a criminal court, the best example that I can think of is when I've faced contempt hearings in family law matters, when someone perhaps is behind on payments and are put into a difficult spot. The law provides what the law provides. And you would listen to that and listen to those. And when mercy may make the situation better, in a situation like that, it's something that you consider. But the law is something that has to be applied evenly. I find also that the approach to people in your courtroom can always involve mercy and grace. But the law application is what you all have written it to be and must be done so.
And Representative, that is something that I face on a daily basis in criminal court. and I've wrestled with that a lot with my faith and with my job. And if you look at the sentencing statutes in Tennessee, one of the key provisions that this legislature has passed has said the court should met out the least onerous sentence that is consistent with accomplishing the purposes of the Sentencing Act. And so the approach that I have taken is if extending mercy to a defendant would result in an injustice, then I should not extend mercy, because my job first is to reach justice. However, if I can still accomplish justice by extending mercy, then I should extend mercy. And I err on the side of extending mercy when I can. And I think one of the great examples that we have in Knox County, we have drug courts to deal with the many defendants that we have with substance abuse issues. Rather than sending them penitentiary, we'll run them through drug court. We've just started a mental health court, thanks to our clerk, Mr. Hammond here, who was very instrumental in getting that started to deal with these individuals who have mental health. That is all mercy, to seek to get help for these individuals rather than send them to the penitentiary. So I'm very proud. I do have a reputation, I will admit, of being tough on sentencing, but I also love mercy because I believe that's what I've been called to do by my Heavenly Father.
Very good. Thanks, sir.
Mr. Chairman, just a couple, well, actually, one more question and one comment.
All right, thank you, sir.
But when I think about America, and I think about the principles and values that we were founded on, and they've been reiterated through some court decisions, then I think about equality and equity. I think about equality in terms of how the law is written, incorporating the principles and the values of a democratic republic to be fair. But part of that fairness requires not only to be written into the law with equality, but how you apply it. And for me, it's you get the justice you deserve. And I think about that in terms of both sides of the coin, whether you're in a criminal case, whether you're the defendant, or whether you've been wronged. So can you speak to that?
Yes, sir.
Equality and equity is what I'm talking about balancing here.
Yes, sir.
Equity being what you deserve from the actual application, equal application of the law.
Right, yeah. So first and foremost, what I would say is it's the obligation of the judge to follow the sentencing laws, regardless of what they believe the results would be. But as I said in my previous answer, the sentencing laws give a lot of discretion to the courts to shape, if it's something that's not mandatory prison, to shape ways to address the underlying concerns that that person has. And so, as we all say, justice is blind. And so when you're making those decisions, you don't look at anything about the socioeconomic aspects of that person. You look to see what their needs are. Is this somebody who has difficulty with mental health medications? What programs do we have in our community? Regardless of where they're from, what their economic backgrounds are, we will get them that help. And so I don't know if I'm answering your question completely, but I think the best response to that is it really is blind, that we are looking at that person as an individual, not as just defendant number 2 that's been in front of me this day.
Very good. Thank you. Leader Lambert, I have you next on the list.
Mr. Chairman, can we hear Judge Smith on this?
Oh, I'm so sorry. Judge Smith, you're recognized.
To go back to the example that I used before with regard to, say, a family law contempt case, those are situations where I am in a different situation. There's no sentencing guidelines. There are remedies available, and I am able to apply everything that I have in my toolbox to try to continue to get people on the right path for getting themselves out of that bad spot, if that makes sense. I don't have much of a better example, since I primarily do preside over, well, exclusively in circuit court and in the Court of Appeals position that I'm seeking confirmation for. It is a civil arena, so I don't think I have as many examples as Judge Sword would.
Right. Thank you, Chairman. Thank you, and wish you the best.
Thank you, sir.
Very good. And thank you so much. Leader Lambert, you're recognized.
Move that we return to session.
Very good. Any objection? Seeing objection, members, all those in favor? We're not in session. Members, we have objection for the committee to be moving back into session. All those in favor of moving back into session say aye. Opposed say no. Aye. Ayes have it. We're back into session. All those in favor of going back into session say aye. Aye. All those opposed say no. No. The ayes have it. Thank you all so much for being here today. Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, it's my honor, it's my privilege today to nominate my friend and my colleague, Judge Valerie Smith, to the Court of Appeals for the Western Section.
Very good. That's a proper motion, proper second. Members, all those in favor, and we do not have to be on the board for this vote, so we're going to be voting as a voice vote. Aye, if you want to confirm Judge Smith to the Court of Appeals in the Western Districts, and vote no if you do not. There's nothing wrong with that. Members, any objection to having a vote on the board? Seeing none. All right. Let's do it. Members, all those in favor of a positive recommendation for Judge Valerie Smith to be appointed to the Western Court of Appeals, vote aye. All those opposed, vote no. Has every member voted? Does anyone want to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 1 present not voting.
Very good. Congratulations, Judge Smith, on your positive recommendation. Representative Davis, you're recognized.
Thank you, Mr. Chairman. It is my honor and truly a blessing that I get to make a motion for the appointment of Judge Stephen Sword to the Court of Criminal Appeals for the Eastern District of the state of Tennessee.
Second. That's a proper motion, proper second. Members, we're going to be voting whether or not to offer a positive recommendation for Judge Steve Sword to fill the vacancy in the Eastern District for the Court of Criminal Appeals. All those in favor, vote aye. Aye. Well, on the board. All those in favor, vote aye. Opposed, vote no. Has every member voted? Would any member like to change their vote? Madam Clerk, if you would take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 4 present not voting.
Very good. Congratulations, Judge Sword, for your positive recommendation. And appreciate you all for being here today. All right, members, we have a calendar. We are going to move without objection to item 26. Item 26 by Chairman Williams. You've got a motion and a second, sir, and you're properly recognized. Do you have an amendment you need to put on this?
Thank you. Yes, Chairman. I have 2, actually.
Very good. And I'm looking at
5109.
Yes. Is that what you'd like to move forward with?
Yes.
Okay.
Yes, and I'm sorry. The 5109 is a technical change to the original amendment. The first amendment needs to be adopted as drafting code 4595.
Just give us one moment, Mr. Chairman. Chairman Williams, you're recognized.
Thank you. I just am amazed at the overall abilities of our staff and their ability to tell me what I'm doing wrong. So congratulations. You are correct, Chairman. The drafting code number is, I do not need the original amendment. The only amendment that I do need to adopt is drafting code 5109.
Any objection to adopting House Amendment 5109? We've got a proper motion, proper second. Any objection? Seeing none, all those in favor of adopting House Amendment 5109 to House Bill 1177 say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Chairman and members. This bill is a follow-up to last year's bill that this body supported that was called Jillian's Law in honor of the young lady who lost her life that was a Belmont University student. She and I never had the opportunity to meet, but I did get a chance to spend quite a bit of time with Leader Lamberth, who ran that bill last year, in honor of her, to make sure that we protect those in our communities who have committed, who couldn't stand trial because of their mental capacity. What this bill would do is it extends the requirement from 11 months and 29 days to 2 years that any misdemeanor charges against a person found incompetent to stand trial due to mental illness may be retired after the date of that arrest. It also adds language to ensure that if a defendant remains in custody after the expiration of those 2 years, that the Regional Mental Health Institute must provide an update every 6 months to keep the case on the court's radar. In addition, under this amendment, the court would be notified of the discharge, which shall include outpatients treatment plan, which accounts for the reason to support safety for our communities from those who cannot stand trial because of their mental health. With that, Chairman and members, I'm happy to attempt to answer any questions you might have.
Very good. Thank you for that explanation. Members, any questions? Representative Johnson, I have you first on the list. You're recognized.
Thank you. Well, part of my concern is that this ensures that people get stuck in the system with no way out and no access to treatment. One of the big misconceptions is people with intellectual disabilities. I think there's a difference there than a mental health disability and an intellectual disability, where restoration is only at 40% for those with intellectual disabilities. And so then we only have 5 to 6 beds in the state for those folks, and they are always full. So what we're talking about are people without available treatment. What are we doing in that respect?
Chairman Williams.
Thank you. Thank you for the question. We worked with those different groups as it relates to extension. Originally, it was only a year. We've extended it another year to make sure that we did ensure that all the citizens that needed this, from those with disabilities and those with just mental health and not mental health and disabilities, were getting the treatment that they needed in order to make sure that that worked. We worked with those departments to make sure that the duration of time was long enough so that they could get the help. Because the key here is protecting our communities by making sure these people get the mental health services they need and they're not just being incarcerated or held away from those treatment. The goal here really is to try to open more beds. I know Leader Lambert had the opportunity. I was invited to meet with some stakeholders here in the Nashville area who have the ability to expand the number of beds, and we're looking to try to figure out how to expand the number of beds. In their instance, they have the capability of doubling the number of beds that they currently have, which would provide those resources that you and I both want to need.
Representative Johnson, any follow-up?
Yes, I guess what I'd like to see is that happen before we start this, so that these folks have a place to go. Because also with those with intellectual disabilities, we're talking about it takes 6 to 9 months, which might be different from someone with mental health issues, just getting the medications they need. We're talking about perhaps 6 to 9 months receiving care if we are going to see that 60% that can make a change. So I guess what I would ask is I would like to see us have the beds before we put this into place.
Chairman Williams, any follow-up?
Thank you. I think we share in that. I think we need to have as many beds as we can. I know this body, particularly in support everyone that supported the budget last year, expanded the number of beds that we could do that. I think it was $2.6 million. We can expand beds. Leader Lambert and I are working on doing just that, and I look forward to working with you to help do that, because I do think we need, not just in this space but all across the state, we need more beds, and I think we need to figure out ways in order to fund those beds, and particularly partner with those in the short term who have the capacity to expand the number of beds in which they serve this population with.
Very good. Leader Lambert, you recognize.
Thank you, Mr. Chairman. And Chairman Williams, thank you very much for carrying this bill. I know it's a follow-up from a bill that's very dear to your heart, mine as well, from last year. And based on some of the debate we had last year on that bill, I did go out, and I would encourage anyone that would like to tour the Harold Jordan Center, which is a very good facility. But the problem that they have is it is very difficult to get someone back up to the point where they need to be within a year. And what has to happen right now, regardless of where you are in your journey, and they have empty beds right now, they need to be staffed, which is why there's going to be additional money, I hope, in the budget that we would all vote on in a few weeks, that would shift money over within DDAA's budget to staff staff some additional beds. Now, what they have seen is a decrease in the number of beds that are needed. I think they had 4 people there when I was there, and they had 2 people that were on the waiting list. And so there's not a long waiting list, but there shouldn't be any waiting list. And I think that's something we could all agree on. But it's really hard to get these folks the services they need because they're intellectually disabled within a year's time. So to say 2 years so that they can really get them on a good path is a much better thing than having an artificial deadline at 1 year where it just has to be dismissed. Thank you, Mr. Chairman, and thank you for carrying the bill.
All right, very good members. Anyone else have any questions for Chairman Williams? All right, we ready to vote? Question's been called. Any objection? Seeing none. Members, looks like we're ready to vote to send House Bill 1177 as amended to Finance, Ways, and Means. Members want to vote aye. Anyone vote no? If member voted, anyone want to change their vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 17 ayes, 5 noes, and 0 present not voting.
All right, congratulations, sir. House Bill 1177 as amended moves on to Finance and Ways and Means. Thank you.
Thank you, Chairman, members.
All right, members, if we can go back to item number 1, House Bill 1089. Representative Hicks, thank you for being patient. Sir, you have a motion and a second. I'm looking at 2 amendments. I have House Amendment 4598 and I have 5883.
You are correct, Mr. Chairman.
Okay, did you need to adopt both of those amendments, sir?
The latter.
The latter, okay. Members, you got a motion and a second on 5883. Do we want to go ahead and adopt that? Question's been called. Any objections? Seeing none. Members, all those in favor of adopting House Amendment 5883 to House Bill 1089 say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized, sir.
Thank you, Mr. Chairman. This bill aims to ensure that individuals convicted of certain criminal offenses undergo mental health evaluations as part of their court sentencing process to better understand the mental health needs of offenders and ensure that the appropriate intervention and treatment are provided. Mental health evaluation can reveal any underlying mental health issues which could contribute to further criminal behavior. Providing this crucial mental health care could reduce the number of repeat offenders and improve defendants' chances of rehabilitation. The mental health evaluation applies to several offenses such as child abuse, domestic assault, and cruelty to animals. The department will evaluate defendants convicted of one of these offenses before their sentencing hearing. These evaluations must be conducted by a community mental health center or a qualified mental health professional designated by the commissioner. The center or mental health professional will submit their evaluation to the courts, and these can be used in the sentencing process. By addressing mental health concerns in the sentencing process, this bill represents an important step in the state toward a more rehabilitative criminal justice system that acknowledges the complex relationship between mental health and criminal behavior. This bill not only seeks to improve individuals' lives, but also aims to enhance public safety and well-being by enhancing treatment of mental health issues among offenders. This could lead to a potential lower rate of reoffending and better integration back into society. With that, Mr. Chairman, I'll be happy to answer any questions.
Very good, and thank you for that, sir. First on the list, I have Representative Johnson. Ma'am, you're recognized.
Thank you. I absolutely agree with what you're doing here. My question is more about implementation and the concern that cannot the state handle all these mental health evaluations? Do we have capacity for this? I know that it takes 90 days currently for some mental health evaluations in our courts. So are we going to be ready to take this on when this happens?
Representative Hicks, you recognize.
You know, I believe this will be a good goal, a good something that the state can work toward. I do believe that we're, in talking to the mental health folks across the state, I think they are gaining ground because of the legislature has actually implemented more money for them in our budget. So I think that we'll get there. This is something that we have to afford to do because the correlation in between these two things is absolutely unbelievable. So we have to, this is a great place to catch people at a place in their life that you can make a big difference.
Representative Johnson, any follow-up?
Yes, I agree with you, and I just hope that we're going to keep up so that can get done instead of, getting bogged down. But, a lot of these things we're doing, we need to keep up, and we need to prepare for it when it happens and make sure we have those monies available, because you are right, this is valuable information.
President Hicks.
Thank you, Mr. Chairman. And we have some programs already through our recovery courts that's actually working. And Speaker Sexton understands that those things are working, and I think he understands this issue and really wants to try to do something about it. So thank you.
Very good. Representative Powell, I'll have you next on the list.
And I address this. I share some of the same concerns I know in the subcommittee, and I appreciate your answers. I agree with you. I totally understand the correlation. Those that abuse animals and what that ends up leading to, and some of these other things that are in the bill. My concern, though, is again just the lack of adequate health care for mental health treatment in our state, and I fear that something like this could potentially bog that down further. I wish we would expand Medicaid, and that would solve a lot of our problems, but. I'm just torn on this bill because I completely agree with what you're trying to do, but I just know that the system is already burdened as it is. But thank you for what you're trying to do.
Thank you.
Very good. Representative Hicks, any follow-up?
Thank you.
Very good. Members, I don't have any other questions. Are we ready to vote? Leader Lambert?
Move previous question.
All right. Members, I see no objection. All those in favor of sending House Bill 1089 as amended to Finance, Ways and Means, vote aye. All those opposed, vote no. Has everyone voted? Anyone want to change their vote? All right, Madam Clerk, if you take the vote, please.
Mr. Chair, you have 21 ayes, 0 noes, and 1 present not voting.
Very good. Congratulations, sir. House Bill 1089 as amended moves to Finance, Ways and Means.
Thank you, Chairman. Thank you, committee.
Thanks, sir. All right, members, I have the next bill on the calendar, so if Vice Chair Davis wouldn't mind taking the gavel there.
All right, members, we've got House Bill 1093. Will the sponsor, we've got an amendment on this, 5877, which rewrites the bill. Would you like to add that to your bill, sir?
Yes.
All those in favor of adding this amendment? Say aye. All right. Mr. That was a dead. All right, Chairman Farr, thank you. We're ready to have you explain your bill.
Okay, thank you so much. Members, I'm carrying this bill for Speaker. Speaker Sexton brought this to me. I think it's a great piece of policy and legislation. The goal of this bill is to increase public safety in 3 very simple changes. Number 1, to clean up the definition to make sure that the Glock switches, which are already illegal, stay off our streets, as well as increasing the penalty for these from a Class E to a Class C felony. It also adds language about felons who are in possession of ammunition, which is already illegal at the federal level. We are also increasing the minimum penalties for someone convicted of aggravated assault, specifically when a firearm is used from within a motor vehicle, will not be eligible for release until 100% of their sentence is served. By adding this language and changes and provisions, we can make Tennessee a safer place, strengthen our criminal system, and hold offenders accountable for their actions. And I'll be happy to answer any questions that any member may have.
All right, members, do we have any questions? Chairman Todd?
Thank you. I guess I wanted to ask, just haven't researched this enough, but does this restriction on certain items only apply to convicted felons?
Representative Todd, or excuse me, Chairman Todd, that is my understanding that yes, this only applies to convicted felons.
Okay. So law-abiding citizens, if this were, let's say, if a federal restriction of certain things like, I see machine guns, was taken off of the restricted list, does this make our law more strict than that with law-abiding citizens?
This will not affect any ability for a law-abiding citizen to maintain ammunition. This law is specifically tailored for those who have been deemed found guilty as a felony. Someone who just does not have the legal right under our Constitution to have a firearm. And federally, right now, these Glock switches, they turn, basically make a pistol into an automatic, almost fully automatic gun. And also, it also allows, this prohibits felons having ammunition. I mean, there's no reason for a felon that can't have a firearm should have any sort of ammunition as well. So we're not impeding on anyone's constitutional rights here, Chairman.
Chairman Don.
Thank you. And that's really what I'm getting at with the case, matter of fact, that was just mentioned in our confirmation hearings a few minutes ago, Rahimi, and many other federal cases have said that if something was outlawed during the, I guess, ratification of our Constitution, then there'd be a text in history today that we would have to go by. And so I guess that's what I'm getting for a law-abiding citizen. So I'm just trying to make sure I'm understanding this, the direction of this bill, that we're talking about things that apply to convicted felons and not law-abiding citizens, creating anything new, any kind of new restrictions for law-abiding citizens, especially under the Bruin construct.
And we are not.
Okay. Thank you.
Thank you.
Any more questions, members? You withdraw? Thank you, sir. Representative Hardaway, you're recognized.
Thank you, and thank you to the sponsor. Just want to go on record as fully supporting this bill. I think what we need to do is to balance the rights of the victim along with the rights of the defendant, but this is going to save lives. When you spray those bullets into the community, ain't no telling who you're going to hit. So I think the sponsor for this is long overdue. Thank you.
All right, members, we're ready to vote without any objection. Mr. Clerk, will you open the board? All those who want to change their vote? All right, Mr. Clerk, will you record the vote?
Madam Chair, you have 22 ayes, 0 noes, and 0 present not voting.
All right, Mr. Chairman, your bill moves to finance as amended. Thank you very much.
Thank you, Madam Chair. All right, members, if we could move down to, and I'm sorry I'm kind of hopping around for the members that are waiting, but there's a couple of things that we need to move on. Item 10, Representative Garrett. Without objection, we'll move to item 10.
Thank you, Mr. Chairman.
And you are properly recognized. You got a motion and a second. I'm looking at two amendments, House Amendment. The latest one is 4551, and I have 4452 as well. 4551?
That's right.
Okay, you got a motion and a second. Members, any objection to adopting that amendment? All right, seeing none. All those in favor of adopting House Amendment 4551 to House Bill 1038, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, sir, and you're properly recognized.
Thank you, Mr. Chairman. I don't believe this is my amendment. I believe the amendment is moved by Leader Lambert, for which I have no opposition to the amendment. So I defer to him for explanation of the amendment.
Members, any objection to recognizing Leader Lambert? Seeing none. Leader, you're recognized.
And Mr. Chairman, my understanding, we just put that on the bill, so I'll be happy to describe it, but we did just adopt it, correct?
We sure did.
Yep. So it goes directly at the recent shooting that happened at Antioch High School. The juvenile records of an individual, a child that commits a murder in a school, upon their death, those records should be public. I think everyone, both in this room and in the public, and especially the children and families at Antioch, need to know exactly what that individual's history was, and then we can evaluate how to prevent horrible murders like that from occurring. And until you have the information, it's hard to do so, and that information should be released. So that's what the amendment does.
Very good. Members, any questions for Leader Lambert on that amendment, which we've already adopted, but he was kind enough to explain it again? All right. Representative Garrett, you're recognized.
Thank you, Mr. Chairman. And then the original bill before the amendment was put on, that's why I wanted that separation of what his amendment did versus what the original bill did. This original bill just requires the juvenile courts to maintain their unified system like we passed maybe 2 legislative sessions ago. We appropriated about $75 million for our court systems where they could actually talk to each other. This is just going to apply also to our juvenile courts, so they can also, the data can be housed in one place. There is an appropriation to help and assist the juvenile clerks with that changeover, but that's what this piece of legislation does. Mr. Chairman, I'll be happy to take any questions.
Very good. Members, I have Representative Johnson. You're first on the list. You're recognized.
Thank you. I guess the one thing I'm hearing from constituents is, like, this bill by itself is not a concern, but they're seeing several bills related to juvenile records. So their concern, and I'm not sure how valid their concern is, but the concern is that we're, the way we're moving towards keeping juveniles' records, that we are putting them in a position of perhaps these records becoming public or more opportunity for these records to become public. Is that something that concerns you with this bill at all?
Representative Garrett.
Thank you, Mr. Chairman. Thank you for that question, Representative Johnson. This bill doesn't have anything to do with access. This is simply the software, the platform that holds the number of cases, what they are, et cetera. That information, most likely, if there is some sort of divulgence of any type of records in juvenile court, that would either have to be handled by the judge by request, or is already something that's protected and cannot be accessed by the public. This is simply so the clerk in Knox County has the same information that my clerk would have in Sumner County. So it doesn't have anything to do with the public records request. If it did expand that opportunity, Representative Johnson, I would not be doing this particular piece of legislation. So I can assure you it does not do that, but that's a very good question.
Any follow-up, Representative Johnson?
Yeah, just to follow up, it wasn't related to a public records request, but I'm trying to remember the other bill in juveniles that allows some information to be transferred over to adult court, in which case that information is made public. And so that's why these two bills interacting together is kind of what my concern was. But thank you.
Very good. Members, any additional questions for our sponsor? Seeing none, are we ready to vote? All right. Any objection to voting? All right. Seeing none. Members, let's ready to vote to send House Bill 1038 as amended to calendar and rules. Everyone voted. Everyone voted? Vote aye if you want to send it. Vote no if you don't. Has everyone voted? Anyone change their vote? Madam Clerk, you take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 2 present not voting.
Congratulations, sir. House Bill 1038 as amended is moving to calendar and rules.
Thank you, Mr. Chairman and committee.
Very good. Members, if we could hop back to item 3. I see Chairman Halsey there. Waiting patiently. It's House Bill 1328. I don't see any amendment on this, sir, and you're properly recognized.
Thank you, Mr. Chairman. Thank you, committee. Recently, we started a pilot program of notification when it came to court issues, particularly for victims, and it dealt with the movement of bail hearings, pretrial hearings, trial hearings, and sentencing, and it was a way to notify victims and even other people who are interested in it. And it has done so well. It's operated by the Sheriff's Association. And so all this bill does is make it permanent, because it's going to sunset June 30th of this year, 2025, and this just sets it in stone.
All right. Thank you for that explanation. Members, any questions for Chairman Halsey? Hardaway, did I see your hand? Or were you? Nope, guess not. The question's been called. Any objection to the question? Seeing none, members, like we're ready to vote. Send House Bill 1328 to Finance, Ways, and Means. All those in favor vote aye. All those opposed vote no. Has the member voted? Anyone change their vote? All right. Madam Clerk, take the vote.
Mr. Chair, you have 22 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations, sir. House Bill 1328 as amended is moving to Finance, Ways, and Means.
Thank you, Mr. Chairman. Thank you, committee.
All right, members, that brings to item 4, House Bill 555. Sir, you've got a motion and a second. I don't see any amendment, and you're properly recognized.
Thank you, Mr. Chairman. Members, I'm sure many of you will remember this from last year. Leader Lamberth and I have been working on this. Essentially what this does is it increases from a Class E felony to a Class D felony the penalty for the offense of burglary of any freight or passenger car, automobile, truck, trailer, boat, airplane, or other motor vehicle. Several stakeholders in support of this: Tennessee Railroad Association, Tennessee Chamber, Tennessee Trucking Association, the Greater Memphis Chamber, Memphis International Airport. I can keep going. I've got a long list, but that's what it does.
Members, any questions for Representative Capley? Representative Johnson, I saw, well, question's been called. You want to withdraw that or keep it? You withdraw. Okay, you're recognized, Representative Johnson.
Thank you. Again, I don't know if did you sort of add boats and other things to this since last year, or was that on there already from last year? I'm trying to recall.
Bill's a little different than the one last year.
Okay. So again, I'm gonna ask as a boating family and fisherman family, if you're getting your boat, you're pulling your boat out of the water, and there's two people getting their boats out. If somebody sees a cooler in somebody's boat and they take a Coke out of their cooler, that's certainly theft without a doubt. is that going to be a Class D felony?
Representative Capley, you recognize.
If your DA is going to take that up and make that a felony, I would be extremely surprised by stealing a Coke being a considered burglary of conveyance or anything like that. So.
Wouldn't that?
Representative Johnson, you recognize.
Yeah, I see that as a problem, but that is something that could happen here, correct?
I'm
Capley,
not an attorney, Mr. Chairman. We'd have to go to legal about stealing Coke cans. Maybe Leader Lambert can help me out there. I don't know.
I have Leader Lambert, sir, if you're recognized to provide us with some direction on whether or not a Coke is a felony.
It may dismay our friend from Knox County, but it's already a felony to do that. Don't do it. So it's already a felony to steal something out of a vehicle. He's just making it a D felony instead of an E felony.
Shout out Coca-Cola.
For stealing the Coke. Okay, gotcha.
Don't steal the Coke. Don't have to worry about it.
Shout out Coca-Cola.
Members, any additional questions for
Coke Zero,
Representative
man,
Capley?
so.
Seeing none, we ready to vote? All right, any objection? All right, members, looks like we're ready to vote whether or not to send House Bill 555 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member like to change their vote? All right, Madam Clerk, if you take the vote, please.
Mr. Chair, you have 16 ayes, 5 noes, and 0 present not voting.
Congratulations, sir. House Bill 555 is moving on to Finance, Ways and Means.
Thank you, Chairman.
Very good. Brings us to item number 5, House Bill 745 by Representative Stevens. Sir, you've got a motion and a second on the bill. I see Amendment 3889. Is that something you'd like to adopt?
That is correct. It rewrites the bill,
All right,
yes.
You've got a motion and a second on that. Members, we will go ahead and adopt that amendment. Any objection? Seeing none. All those in favor of adopting House Amendment 3889 to House Bill 745, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're recognized.
Thank you, Mr. Chairman. This bill deals with banking, and it does two things. First is it extends the amount of time a bank has to respond to garnishment orders from 1 day to 2 days. And second, it allows a prevailing bank to recover attorney fees and actions for check fraud claims under the UCC.
Very good. And thank you for that explanation. Members, any questions for Representative Stevens on the bill? All right. Very good. I have no one on the list. Any objection to the question? Seeing none, looks like we're ready to vote. Whether or not to send House Bill 745 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has everyone voted? Anyone like to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Congratulations, Representative Stevens. House Bill 745 as amended is moving to calendar and rules.
Thank you, Mr. Chairman and committee.
Thank you. That brings us to item 6. Is Representative Gillespie near here? I do not see him. Leader Lambert, excuse me.
Mr. Chairman, I can run it if you need me to.
Very good.
Motion.
Sir, you got a motion and a second. I'm looking at a bill with no amendments, so you're properly recognized.
Thank you, Mr. Chairman. It does exactly what it says it does. It just makes permanent the exclusion of certain narcotic testing equipment for purposes of that being paraphernalia.
Okay. Members, any questions for Leader Lambert on House Bill 113? Seeing none, are we ready to vote? Any objection to the vote? All right. Members, all those in favor of sending House Bill 113 to calendar and rules, vote aye. Opposed, vote no. Has every member voted? Would anyone like to change their vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Very good. Thank you. Members, House Bill 113 moves to calendar and rules. Members, we could move. Do I see Chairman Vaughn? Is he here? Chairman Vaughn, I don't see him. Members, we're going to go ahead and take up item 7. I typically don't do this, but I'm carrying this piece of legislation for the Secretary of State's office. It's a fairly simple bill. I'd like to go ahead and get it moving if we could. It's House Bill, item 7, House Bill 1340, members.
All right, members, thank you very much for your patience. So do I have a motion and a second for House Bill 1340? Thank you. I see no amendments on it. Chairman Farmer, would you like to explain your bill, please?
Yeah, members, all this does is provide that folks that are going to be issuing online notaries have the education and the knowledge to do so properly. Thank you.
All right, members, and Madam Clerk, will you open the board for voting? Have all members voted? Does anyone wish to change their vote? Madam Clerk, will you record the vote?
Madam Chair, you have 21 ayes, 0 noes, and 0 present not voting.
All right. The sponsor, this bill moves to calendar and rules. House Bill 1340 moves on to calendar and rules.
Thank you, Madam Chair, Committee. All right, members, I do not see, item 8 is House Bill 1342 by Chairman Vaughn. I do not see him. He's on his way down. Members, let's roll that bill one spot. So without objection, we're going to roll House Bill 1342 one spot. That brings us to item 9, House Bill 1315. We've got a motion and a second. Leader Lamberth on that bill, and I see House Amendment 3652.
Yes, sir.
That should be, members, motion, second on the amendment. You've got it. We'll go ahead and adopt that amendment, members. Any objection to adopting House Amendment 3652 to House Bill 1315? Seeing none. All those in favor say aye. Opposed say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized, Leader Lamberth.
Thank you, Mr. Chairman. It just gives some more flexibility to those that have an additional lock device on their vehicle.
Very good, members. Any questions for Leader Lamberth on the bill as amended? Seeing none. Any objection to the question? Seeing none, are we ready to vote? All right, members, all those in favor of sending House Bill 1315 to, as amended, to calendar and rules, vote aye. Opposed, vote no. Has every member voted? Any member like to change their vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 22 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations, sir. House Bill 1315 as amended is moving to calendar and rules. I'm sorry. Chair Lady Littleton, you're recognized, ma'am.
Thank you, Mr. Chairman. While we're waiting, I make a motion that we pull up number 27, House Bill 787 by Chairman Moody, please.
Members, any objections? All right, seeing none. Chair Lady Moody. And you have a motion and a second. And we're on item 27, folks, House Bill 787. Chair Lady Moody, I see House Amendment coded 3449. Is that? Okay, you've got
correct.
A motion and a second. You want to go ahead and adopt that?
Yes, sir.
Members, do you have any objection to adopting House Amendment 3449 to House Bill 787? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back in the bill as amended, and you're properly recognized.
Thank you so much, Chairman and committee, for taking me out of order. This is really a simple bill. It's just a study per the request of our General Sessions Judge in Tipton County, Mr. Mo Eccles. And he is seeing a trend with those members of our community that are charged with drunk driving and those charges. So he wanted to call the study the Distance to Drive Program Study Committee, and it would last a year. And he wants to help the folks that doesn't change any of their charges or anything like that. But once they get into that system, they seem to get caught in what we call a vortex of fine after fine after fine. They can't drive to go to work. So it would be a study to look at it kind of like a recovery court, if that helps you imagine what he's looking at, and just to see if it's a feasible thing that we could come back and bring. But it's just a study for this bill's purposes today.
Thank you for that explanation. Question's been called. Any objection? Seeing none, members look like they're ready to vote. Send House Bill 787 as amended to Finance, Ways, and Means. All those in favor, vote yes. Opposed, vote no. Has every member voted? Would any member like to change their vote? Madam Clerk, would you take the vote?
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Very good. Item 27, House Bill 787, as amended, is moving to Finance, Ways, and Means. Congratulations.
Thank you. Appreciate it.
All right, members, that brings us back to item number 8, House Bill 1342 by Chairman Vaughn. Sir, I do not see an amendment on this bill. Looking at House Bill 1342, sir. Yeah, and I apologize. We'll try to get you, but we need to, out of respect for the next committee. Thank you. Yes, we will. Members, so without objection, we're going to roll all remaining items to next week's calendar, and without objection, we'll stand adjourned.